Welcome. My name is Paul Thompson. I'm a partner here at the Washington office of McDermott, Will & Emery. Welcome to Cartel Law Update, staying on the right side of the law. A few administrative issues before we begin. First, you'll notice on the screen that you have in front of you there's a chat box. At any time during the presentation that you want to type in a question, please do, and we will take it and try to answer it or try to address it. This is an iterative process, so don't be worried about waiting till the end. Enter your questions at any time that you want. And second, if you are in New York, at 50 minutes into the presentation, I will read out a code that will be the CLE code. So stay tuned for that at about 50 minutes from now, and I will give those in New York their CLE code. It is my pleasure to be joined today for this presentation with two fantastic partners in our Washington office. First, I am joined by Mary Strimmel. Mary has been with us for several months. She has a 20-plus year career dealing with antitrust issues that ranges from working early in her career on the plaintiff side, doing complex antitrust, price-fixing class action cases, and then she made her way into the antitrust division, where she has dealt with almost every industry imaginable on the civil side. And her last stint at the Department of Justice was she was the founder and the head of a new criminal division in the antitrust section known as Criminal 2. So we are really, really thrilled to have Mary with us today to help us address some of these issues. I'm also joined by Stefan Meisner. Stefan has 17-plus years of experience in the antitrust space. He, too, has dealt with both civil antitrust cases, large, complex commercial price-fixing class action cases, and multi-district class action cases, and criminal DOJ investigations. He has run global cartel investigations involving multiple jurisdictions. And he was lead counsel in Mars class action case that was in Pennsylvania and in the Third Circuit that led to a dismissal of all claims against Mars. And those of you who do antitrust work will be very familiar with that case. So we are going to start today by just giving you a brief update about what we'll cover. First, we're going to look at what gets people in trouble, and then how to stay out of trouble, or in many instances, just the appearance of trouble. Because as we'll see, there are a lot of things that create appearance or optics problems that may not ultimately have substantive problems related to them. In addition, everybody who's participating in this webinar will get a copy of this flip book, which is a new ABA publication that came out at the end of March from the antitrust law section of the ABA, and our own Mary Strimmel was the chair of that section who led this effort to put out this flip book. This is a great book. It's portable. It's readable. It's designed to be carried around. It hits some of the basic concepts we're going to hit today in a very readable, understandable, lay fashion. So you'll be getting a copy of this, and I think you will find it very worthwhile. So just to begin us off, I think the first question that a lot of people have is, what are we talking about? What is cartel conduct? So Mary, why don't you take a stab at addressing that issue?
Well, people ask whether lawyers can ever keep things simple, and hopefully the flip book is an example of lawyers trying to keep things simple. It's short and sweet. And similarly, with the definition of cartel conduct, it's actually also pretty simple. It's one of the few things in law that's a list. Price fixing, bid rigging, market allocation, customer, territory, or supply allocation. Those things are what we mean by cartel conduct, and those are criminal offenses under U.S. law and in some other places around the world as well. Now, one important thing right off the bat, and when giving these presentations, a lot of people ask, hands go up right away. What about if I'm a manufacturer and I have distributors who are organized by territory? Am I engaging in cartel conduct? The answer is no, because cartel conduct is horizontal in nature, and that's the next bullet on the screen. It's horizontal only. So participants at the same level of the market who engage in these types of things, that's what we're talking about. Now, the other thing we're talking about that's a key point here is that these are agreements in restraint of trade. That's what the statute says. So without an agreement, there can't be cartel conduct. And an agreement is to be read broadly. It can be explicit, as simple as I agree, or it can be implicit. Parties that talk and communicate in a way as to create a gentleman's agreement or a wink and a nod, that can be cartel conduct as well. So it's really important to be aware that the agreement prong here is read fairly broadly. Circling back to a second on price fixing, that's another area that's read fairly broadly. Price fixing includes any agreement to raise, fix, maintain, or stabilize a price. And what that means is even an agreement to manage a price that's moving downwards would be cartel conduct, even if it's going in the quote-unquote wrong direction. One other little thing I would like to, well, not so little, but important update that I'd like to mention here relates to employment markets. Some recent guidance the past 6-8 months or so by the Department of Justice has made it clear that agreements by employers not to poach each other's employees or agreements not to hire each other's employees, those are also horizontal in nature, and they're an allocation of a market, so those may be treated as cartel conduct in some circumstances. So that's an important update that we wanted folks to be aware of. Now, since we're talking about agreements, to have an agreement, you have to have communications. And to have communications, competitors have to be encountering each other in some way. And that's a lot of what we're going to be talking about today, is ways that competitors encounter each other in the wild. You know, we're going to be touring some of those places and talking about what happens there. And one of the things we'll talk about is that you can't avoid all of these situations entirely, so there's a need for some guidance. Some of the ones we'll be talking about are social gatherings, vendor days, trade associations, and joint bidding opportunities. Each of these are situations where interactions that have happened there in cases have led to criminal enforcement actions at times, have led to very costly lawsuits at times. So that's why we can't stress enough that it's important to be aware of the rules of the road. One overarching principle, of course, is to always use your common sense. If you come back from an encounter with, perhaps a trade association meeting or anything else, and you have concerns and you're saying, gee, something happened that I'm not sure was right, this is not a time to really handle things on your own if you're an executive or unsure of yourself. It's a time to go see your GC and get some good quality guidance. And that person most likely will make an effort to document what happened to make sure that if there's a misunderstanding in the future, the company will be protected. So Paul, do you want to kick us off by talking about social interactions?
I do. This is a very difficult area because there is a very simple rule if you want to avoid any problems or the appearance of any problems, and that is that all of your employees should have no friends. And in particular, they should have no friends who are competitors. That's easy. That's not reality, unfortunately. The reality is that all of your people have friends, and they often have friends who are competitors. And it's not uncommon in an industry where folks may have worked together 10 years ago at a different company, or 20 years ago, or worked together for 15 years, and then they went separate ways, and they're each at a competitor. Maybe they're salespeople, maybe they're executives, but they've known each other and have been friendly with each other for many, many, many years. And the question is, when they become competitors, do they break off? Should they break off all of those interactions? I mean, that would be ideal, but it's really not realistic. So what we want to talk a little bit about are what are some of the rules of the road you may want to follow and some of the parameters you may want to set for these kinds of interactions among competitors who socialize together, who might be friends. Areas that create concerns, obviously, one-on-one dinners, having drinks in the corner of the bar together, golf dates where only competitors are present, those will always create questions. There is hardly a DOJ investigation or a civil case that we have been involved in at some point where there's not a question about why did so-and-so play golf with so-and-so, or why did folks have drinks together. It just happens all the time that questions come up, and this can, take up an hour of a deposition trying to explore a dinner. So some topics to make sure your people are really aware of and avoid. If they're having social interactions with competitors, just stay away from industry talk, period. I know it's hard. People spend 80% of their waking life in their job, and it's very difficult to not and naturally want to talk about what's going on at work. But the safest bet is if you're going to have a friend who's at a competitor, talk about golf, talk about baseball, talk about the theater, talk about art, talk about your families. Do not talk about work. And then obviously a subset of that, never ever get into pricing issues, output issues, market issues, customer issues. That is the safest way to avoid any problems. It doesn't mean that the fact that there is an interaction won't raise questions. But if folks are well instructed about what to stay away from, it creates less of the concern of a problem. And if they're well instructed that if something starts to go in the wrong direction, that they know to come to the GC or come to a supervisor to raise that issue, you are often in a better position going forward. Social gatherings that raise less concern but not zero concern are large gatherings, cocktail parties, dinners, where there's a broad attendance with a lot of people, not just competitors. And in those situations, it's wise for your people to kind of steer their way toward non-competitors and not try to engage in a lot of chit-chat with competitors. It's just the safest course of action. I will have you know that either the plaintiffs in a civil case or the Department of Justice in a criminal investigation will want to look at calendars, expense reports, text messages, social media, Facebook, LinkedIn, to see what kind of connections your people have with competitors, what kind of communications they had with competitors. And it's not uncommon in all of these cases on the criminal side that they might have a corporate subpoena that's accompanied with individual subpoenas to individual people, where text messages and Gmail accounts and AOL accounts and LinkedIn pages and Facebook pages and all of that information is sought. So this is an area that is really pried into, and we see it in almost every case. And here are just a few guideposts you can give people to live by without telling them not to have any friends at all. Another area, we call it vendor days. It probably has a lot of terms depending on the industry that you're in, but there are many times when competitors end up thrust together, but it's forced here by a customer or a vendor. There may be a group of vendors. There may be just a single vendor that will bring competitors together for purposes of business meetings and maybe some social interactions as well. This clearly has a pro-competitive purpose. You probably can't be in business if you're not going to show up when your vendor, your prime customer, has a 2-day event and it involves 5 hours of business meetings with their senior people. You need to be there. But you need to be very careful, because in these events sometimes there's speed dating where there might be a whole host of tables in a room and you're going, if there are multiple customers from customer to customer and your competitors are right next door. There may be a hallway in a hotel where you go from room to see customers, and you'll bump into your competitors all the time coming out of meeting with the customer you're about to meet with. There'll be cocktail receptions. There'll be golf outings, and sometimes competitors will be thrust together at a golf outing by the customer where they didn't set the pairings. So just the same rules of the road would apply here. Avoid industry chatter with competitors. Avoid any substantive conversation at all with them. Maybe a hello, how are you, how's your family, and then move on. In any uncomfortable or somewhat inappropriate approaches from a competitor are a reason to go tell your supervisor or tell your GC. The mere fact that a customer is there at these events does not insulate you from antitrust inquiry or problems. Trade associations. Stefan, maybe you could talk a little bit about another area where competitors come together, which is trade associations.
Sure. Thanks, Paul. So trade associations are obviously very common and ubiquitous features of basically every single industry has a trade association. So there are many of them. They've been around, trade associations, for a very, very long time, probably since the formation of the United States of America in 1776. There was a sort of trade associations. Trade associations have come up in the antitrust context in many, many cases, and it's even been addressed by the United States Supreme Court, which has stated quite definitively that mere membership in a trade association is lawful. There are many pro-competitive reasons for it. There are many benefits that trade associations provide to industry participants and even consumers in this country. We've listed a few of them there. Again, very, very well recognized that trade associations are pro-competitive. But nevertheless, trade associations can present some risk because, of course, as has been mentioned by Paul and Mary, there are the opportunities for competitors to be present and engaging in activities together as part of being members of trade associations. We've put on this slide a checklist of best practices with respect to trade associations. Hopefully for those who are participating in this webinar, these will look familiar. In terms of the trade association, it's very important that meetings have agendas prepared in advance, that those agendas potentially get reviewed by council and members council before the meetings take place, that the agendas are followed at the meetings that they describe. At meetings which competitors are present for trade associations, it may be very useful and appropriate to have counsel present, whether counsel is of the trade association or even of members, particularly small meetings, meetings that may take place in conference rooms outside of the general trade association meeting hall, for example, in which fewer competitors are present. More appropriate perhaps to have counsel at that type of a meeting. At trade association meetings, it's important that its members and participants in these meetings are aware of the antitrust rules that may apply to the meeting and their conduct. Often an antitrust benediction of some sort is read at the beginning of the meetings, or in the program materials, do's and don'ts, one-page guidance on antitrust compliance might be present. Those are all very good things to have for trade association meetings. If minutes are prepared of trade association meetings, those minutes be accurate, reflect who is actually present at the meeting. If counsel is present, that's helpful, identifying that individual. If an antitrust compliance rules are read or some sort of benediction is read or one-page do or don't provided, that would be good to note in the minutes. With respect to what do companies who are members or of trade associations do, what are best practices for those? We've provided some points here. In terms of being a member of a trade association, it may be advisable to have a process in place whereby the general counsel's office, the legal department, or the compliance department is aware of the membership in a trade association and know who the people are who are members of the trade association, and have some mechanism for perhaps approving the attendance in that particular trade association. It may be helpful at a central repository within the legal department or compliance office to have the minutes that's prepared by the trade association kept, or any type of report back by a company's members of what took place at the trade association meeting, again creating a record of what took place to avoid any kind of potential future misunderstandings that may come up. Periodic audits of whether being members of the trade association continues to make business sense is another area that a company may wish to engage in with respect to trade associations. And again, that sort of a continuous process for these types of activities to be done and followed up on is also important.
So just a question that comes up here in the context of all of these social interactions, from just bumping into people to vendor days, trade association, is there a better way with your employees to kind of really stick it in their mind that this is important and to have some process for doing so? And I'll throw out an idea. What if during your annual training, this is assuming you have a small sales staff of 20 people or so, you ask them each to document every competitor that you have any interactions with, that you have a friendship with, and certify for me that you haven't in the past year had any interactions with them about industry topics, pricing, you could list the topics, and assure me that you will continue to comply with this policy for the following year. And then you just did that every year. Is that something that we've seen people do? Does it work? How would it play in a civil case? How would it play with DOJ? I'm interested in reactions.
I would have a positive reaction to considering that, and especially in a high-risk, highly concentrated industry. That's a pretty clear signal to the employees about what's allowed and what's not. I will say I haven't seen it. That may be a good sign that in class action practice or in DOJ that I haven't really seen that. It could mean that companies that are trying to get a handle on that type of conduct in such an assertive way aren't finding themselves in the crosshairs.
I think I personally haven't seen that either, which may say something as well. But I think that various companies may have different components of a compliance program that kind of touch on that type of an idea, Paul. And I think that for the most part, most companies have an antitrust compliance policy, and most people who are employees of the company have to somehow indicate that they have received that policy and are aware of it. In addition, companies should engage in regular training of their employees, be able to ask, be available to answer questions and things like that. But in terms of like my situations where an employee may have a friend who is at a competitor, and they are close personal friends, on a case-by-case basis, you may want to take a stronger look at that. I think that a compliance policy that would have some sort of a mechanism for detecting those types of relationships, and a compliance program that actually works would be perhaps potentially a very good thing to signal to employees that there's strong compliance without necessarily saying to the employee you can't have these people as friends, which of course is kind of out on the outer bounds of possibilities in my view.
So another question we're getting. So this is from someone who says they're a GC, and when do you document when there is a bad interaction? So I think what the question's getting at is, a salesperson comes to me and says, hey, I was at a trade show. Competitor came up to me and said, you want to fix prices. I walked away, went right to my GC. When does that go in the file? How does it go in the file? Does it go in a non-privileged place? Does it go in a privileged place? Yeah. How do you deal with something like that?
So I just want to say at the outset that if your employees are sensitive, let's hope that never happens. But if employees are that sensitive to maybe an uncomfortable situation like that, although your stylized example is about the worst situation that could happen, if they immediately say at the time that happens, whoa, we shouldn't talk about that, I'm getting out of this room or away from you, and then immediately notify their supervisor or the legal department of this, that's great. That is really good. That shows that the employee is complying with the laws, is interested in compliance, and does not want the company to get in trouble. To answer your question, of course, the event itself is not privileged. In fact, it's between a member of one organization and a member of another organization. There's no confidentiality. There's no way to assert privilege over the event occurring. However, reaching out to the legal department for the purpose of, hey, how do we deal with this? I think there might be a problem under our antitrust compliance policy. That communication is certainly privileged. And again, it's important to keep a very accurate record of what happened at the moment in time or soon thereafter that it happened, to avoid any kind of lapse of time and memories change and people may not accurately remember exactly what transposed. That's very important. And then the reaction on how to address that is nuanced. It really depends upon the situation and the frequency that these things may or may not occur in a particular industry, history of investigations and problems, those types of things all factor into it.
The record you may want to have might be the employee, him or herself, writing back, for example, if it's an outreach by email from a competitor, just writing back directly under the guidance of general counsel. I unequivocally reject what you're saying, and that way the record that you have is what we call the noisy withdrawal, if it was an agreement, but nothing to withdraw from at that point, but just making clear that there is no agreement.
There's a great example in the flip book that, you're in a room and a bunch of people are there having lunch or something, and they start talking, a bunch of competitors start talking about the wrong things, right? Talking about price. And the example in the flip book is, whatever you do, obviously you're going to go tell your GC, but make sure everybody knows you don't want a part of it and you're out of it. Even if that means you have to spill your coffee all over the table and say, I'm gone, so that 5 years later everybody remembers, oh, Mary made a stink and she walked out the door. All right, Mary, how about information sharing? Maybe you can address this and what issues arise with information sharing.
Sure. There's two major buckets that information sharing issues fall into. One is information that's shared by or through customers, and then by or involving competitors. So we'll deal with the customers first. Now, when customers share information with the sellers of products, it can either be pro-competitive or it can be anti-competitive, depending on what the information is, how it's communicated, and how it's used. So I think probably for me the best way to think about this is like two different poles. And on one pole, I can give the example of a paradigm case where, let's say, a seller of widgets goes on a customer call and says, offers a quote, here's what I'm willing to sell you these for. And the customer says, no way, man, you've got to be kidding me. Your price is at least 30% higher than this guy down the block who will sell me the same exact widgets. And the seller says, oh, I know you've been my customer for a long time, but how can I really trust what you're saying? And then the customer pulls out an invoice from the competitor and shows it. Now the seller is sitting there able to see not only the unit price, but also the discount terms and the other terms of sale and perhaps the prices for other products as well. All of this information is being shared with them that may be competitively useful for them, something they didn't know before. So what does that mean? Is that good or bad? Well, I think intuitively most of us can tell that kind of information sharing is good. It's great for competition. It's great for the economy because that seller is almost certainly going to turn around and offer a discount. And that information is really the lifeblood of a bargaining process that's inherently pro-competitive, provided that both parties are making their decisions independently. And that's what you have in that scenario that I just provided. And some of us have even probably done that when buying a car or something, getting a quote on a kitchen. We've done that kind of price shopping. It's called shopping. So can that sharing by customers ever be a problem? Well, the answer is yes. And so the example I'll give is kind of the other extreme. Picture, sort of like in the diagram on the right, a highly concentrated market with 3 sellers and, just for purposes of today, 1 buyer. Prices change every week in this market. There's a spot market, and every week the sellers transmit their anticipated future prices for the next week. And let's say that the buyer, for whatever reasons, decides to share that information with the sellers. So the future prices are being shared, and they're being shared regularly. Every single week, Everybody knows that they're going to come out. Everybody knows when they're going to come out. And the sellers, as would not be surprising, coalesce around the same exact price. Now, I want to layer one more fact on, which is one that we see, which is seen with some regularity, and that is that when one of the three cuts price, the others may cut price lower. And if that kind of price cutting happens, in this stylized example, you could see how someone could look at that and say that's retaliation. You could see how someone might look in from the outside and say it's not just information sharing. The sellers are actually communicating with each other. That's what the argument would be. And so that kind of, as we talked about earlier, it takes communication to make an agreement. And so these kind of things can create antitrust risk, even if the parties that are participating there didn't agree, didn't intend to agree. It's the appearance and the optics that can create antitrust risk. So things to watch for include sharing of future prices, prices that are shared solely to obtain a response from competitors, and retaliatory pricing. So next we'll turn to the second bucket, which is information sharing with competitors. And that, I think, if you've been listening and paying attention so far, I'm sure you can tell that that leads to potential issues that are equally, if not more, of concern. They're not cartel behavior in and of themselves to share information, but it is close enough that it results in lawsuits on a regular basis, and that can be very costly, and it can be viewed as the smoke to what would be a cartel fire. In other words, information sharing, if there's no reason for it, would be raising the question of what's really happening behind the scenes. Are these competitors really, in fact, colluding? The one other point that's worth mentioning is that the European Union has stricter rules around information sharing than even the United States has. So it's worth keeping that in the back of our minds as we keep an eye out for this kind of behavior. There are contexts such as joint ventures that may have appropriate firewalls in place, or other mechanisms where there might be clean rooms or other things set up in order to govern information sharing. And when that's done under counsel's proper supervision, obviously that's fine. There's a setting that does kind of straddle this, and that's benchmarking surveys. These things can come up where business people are told by a consultant, hey, we'll take a survey of your industry, we'll find out what your peers are doing, and you can compare your costs, your margins, and other goodies, get some great intelligence, really, on how you're doing in the market. Now, that can be fine in some circumstances, like if the information is anonymized, if there's enough of it and it's sufficiently aggregated that you can't tell whose it is, and if the information is essentially stale, then it can be okay to have a benchmarking survey. But those kind of things really are also in the category of best reviewed by counsel before being undertaken.
So before we leave these interactions among competitors, there is a question that I think relates to social gatherings, trade show, vendor days. What kind of criteria should counsel apply in determining whether there should be a pre-approval process? What events do you want to go to and pre-approve, and what factors should counsel look at in deciding this is not the right event to be going to?
So I think that it's always important to understand that there should be, obviously, I hope, a legitimate business purpose for the meeting in and of itself. And frankly, that may trump everything in terms of the consideration of whether to approve the meeting or not. Again, if this is part of a regular part of a compliance program, this is a component of it. And in addition to seeking that sort of approval, the person seeking approval hopefully has had antitrust training, is aware generally of the antitrust rules that we're talking about right now. And if there's legitimate business purpose for the meeting, we can trust that executive to have the business's interest at heart. So I think that's really important. If there's not a strong business justification for the meeting, if the meeting seems to have some of the benchmarks of wait a minute, is that really more of a social thing that may not have a good business purpose? If there's, again, history of problems, those are things that maybe should be considered. But I think if there's a legitimate business justification in that type of a situation, an executive can be counseled or probably already knows how to conduct that type of a meeting.
Well, let's go to bidding issues. Mary, do you want to address some bidding issues?
Sure. Bid rigging is, in essence, agreeing on who is going to win a bid for an RFP or RFQ and directing or deciding who's going to win, and doing that to the detriment of competition and doing it by agreement. Now, a lot of folks will worry right off the bat when they hear this about bids where they may be partnering with either a competitor or another firm that's in their same industry. And partnering can be okay under the right circumstances, but not always. The ideal kind of partnering that you would want to see as being acceptable in a bidding context is when the two parties are offering some kind of products or services that are complementary to each other, something that allows a bid to go in that would not be possible to do alone, that either they're different services or more of something that their capacity would be too small perhaps, then that kind of partnering can be just fine. And it can be fine even if one used to be the competitor. Now the issue is, of course, is what's the appearance problem if one competitor is dropping out? And it can be a paradigm for real bid rigging if one competitor drops out and becomes the sub for the other. It can be a mechanism for two parties to prevent price competition on a bid and essentially allow that new sub to get something out of it. It would be the theory. So it's important to make sure that in discussions about bidding, parties not create a situation where they're essentially agreeing to diminish competition in that way. There are other patterns that enforcers can look for that should ideally be avoided, and they're things that I think natural competition would avoid. One is if there's the appearance of turf, that one party always wins the same type of bid and another party always wins the other type of bid. I think of the 4-inch widgets and the 6-inch widgets, that neither one crosses over into the other's turf. The natural question is going to be why. Is there a gentleman's agreement, so-called, or is there a wink and a nod agreement not to infringe on the other's turf? And if there is an agreement, then that's going to be cartel conduct. Another issue to be aware of is something called courtesy bidding. And that's when you can imagine two firms in the industry that know each other. One of them bids on something and goes to the other and says, look, the contracting officer has already told me that she wants to award me this contract. But there are only two bidders so far, and she can't make any award to anybody until she gets a third bidder. Can you just come in and just submit something on the high side and we'll be done with it? The fact that that second firm never planned to bid in the first place doesn't matter. It's still cartel conduct. The fact that the second firm didn't really affect the price doesn't matter. It's still a legal problem and a huge antitrust exposure. So,
Mary, a question on bidding, which comes up all the time. You're not going to bid on X customer because X customer has been working with your competitor for 25 years, and you try, and you can never get in there, and you lower price, and the competitor matches, and then you've just left yourself with a lower price in the marketplace, and you essentially hurt yourself going after something you're never going to get. We see this kind of thing all the time in cases. Does that pose issues or problems? You'll see emails, you'll see people talking about, we're not going to go for that one, that's so-and-so's customer, or we just we're not going to waste time with that.
That's an excellent question. Is it okay to unilaterally decide, in essence, not to disturb your incumbent because at the time you make that decision, it's just not worth the effort and you kind of know what's going to happen. And the answer is yes, it is okay to make that unilateral decision. It's probably a good idea to document your unilateral reasons for it, and certainly you don't want to be communicating with the other firm about it. But yes, you can take those into account. You can take into account the likely price response of your competitor in the way that you're describing.
Let's talk about market or customer allocation issues. Stefan?
Sure. And so this is another area of cartel behavior. And basically what we're talking about here are situations in which competitors, horizontal competitors who are competing for sales of, say, the same product, have an agreement that for instance, certain customers will go to one competitor and certain customers will go to another competitor, or some type of a market partition, either by geography or product type. And the geographies, for instance, can be quite large, for example. They can be, for instance, one competitor gets the United States, another competitor gets Europe. So those types of agreements amongst competitors are very unlawful under U.S. law. An important distinction that's easy to make is a situation that we were discussing a few minutes ago, which is a situation in which it's not competitors who are agreeing to do this, but at the direction of some sort of maybe other organization or other company that's at a different level of commerce, let's say, within a particular industry. And you often see that in distribution agreements where distribution agreement from a distributor to an actual company that sells the products may limit a geographic area or a particular customer set. You also see this in intellectual property licensing quite often. Those are lawful types of market or customer allocation. We talk a little bit here about joint ventures. Joint ventures can at times bring two competitors together to form a venture that does something potentially very pro-competitive and lawful, like the creation of a new product or engaging in new types of research and development that the two companies can't reasonably do themselves. And there you're really looking for an integration of functions, even though the joint venture may result in certain products being sold by the venture as opposed to not being sold by the two competitors absent the venture. As is almost always the case in any legal situation or in any situation or parenting situation with your kids, if there's some kind of hint of secrecy in the type of conduct that's going on, it's just an immediate red flag. Trying to hide what you're doing through clever ways of having the accounting department pay for things, for example, is just going to cause problems, always does. And I think generally speaking, in these types of situations, to try to distinguish between lawful and unlawful conduct other than the sort of horizontal aspect of the competitors is always ask, is there a pro-competitive purpose behind what we're doing? And is what we're doing necessary to achieve that pro-competitive purpose? So some points there.
So let's go to, we've identified a whole bunch of issues and problems that come up and things to be aware of, but compliance programs and the importance of compliance programs. So Mary, why don't we talk a little bit about what we can do to try to prevent issues from becoming problems, from becoming lawsuits, from becoming investigations?
Sure. Well, the DOJ has expressed some viewpoints on adequate compliance, and the reason that they have done so, frankly, is because they have companies that appear before them who are saying, look, we made a mistake, we've done something wrong, we acknowledge it, but we want to show you the efforts that we made to prevent that and to mitigate it. And when they're faced with all these companies who are asking either for lesser punishment or maybe no punishment, they have to have a view. And I think one primary component that has been emphasized again and again is that the commitment of the top officers of the company to compliance is a difference maker, because it's really a culture of compliance that companies should be after. We've talked about rules today, and the book has some guidance, but when it comes down to it, there's no substitute for employees really being committed, because if somebody is determined to defy these things, they can do it. So if they know that the top officers are committed, I think the company itself is going to be much the better for it, whether it's being there at the kickoff of the compliance program, whether it's being part of the video, of the CEO being present, the CFO being present. All those are good things. Like any component of adult education, you want to have good content. You want to have engaging content. You don't want to just have a memo that people read and sign. Whether it's having the training be provided live, whether it's being a third-party video. So one thing I've heard that's very inexpensive but a good idea is just showing the lysine price fixing tapes that are available on YouTube as part of a training. That was the chemical that was fixed that was in the book The Informant and the movie The Informant. People like it. It's an interesting way to show people what hopefully they'll never do. But
do you have a view in terms of effectiveness in person versus some kind of an online program?
Well, I think there's a lot to be said for in-person, in particular if it's somebody in their chain who is there in people's chain. I know a lot of times people view a compliance or a GC function as separate from their real world, separate from what they really have to worry about. It's separate from their margins. It's separate from their bonus. It's separate from what they're rated on. One thing that can be incorporated, another thing which may not be very costly at all, is making sure that the executive's evaluation system includes a very clear compliance component. Not only that they participate in and check the box that they did, but are they creating the culture within their own organization? Can you see it in their employees that they are seeking the advice? You know from looking at all these contexts that we talked about today that employees are out there in the world, and if they're not asking any questions, maybe something's going wrong in the engagement process. So top officer involvement, good content, and then everything starts with knowing where to put your resources. And that's where a risk assessment really comes into play. What are the functions and the roles, the responsibilities in your organization where you've got people encountering competitors? What are the ones where layered on top of that you have a sales or distribution or marketing function? And when you've got those things going on, that's when you may not need the highest level of whatever kind of approval you think is appropriate. And again, this has got to be customized for your unique situation, but this may be the pre-approval that we were talking about before. So we talked about training. We talked about having some kind of takeaway, a publication that employees can take with them when they leave the training, so when they need a refresher. It might be this book. It might be something else. And a record-keeping and audit function, just as on the trade association side that Stefan talked about, it's equally important here to be able to demonstrate that your employees attended the training, that they received it, that they understood it ideally, and to check that.
Question about audits, email audits. What is the view on should the company be doing email audits? And then related to that, most companies have salespeople who are all over the place, right? They might be at home offices. They might be using a home phone. They might be using a cell phone that's both personal and work-related. They're probably texting. They might be using social media to communicate with people. How do you audit that? I mean, how do you in any way determine whether your people who are out, 1,500 miles from the home base using a personal cell phone are engaged in any improper conduct? So maybe you guys could address the email issue and then take it from there to text, social media, home office.
Sure. And I think that this is a very interesting question today in particular because a lot of companies are facing compliance issues with respect to data privacy, social media use policies now with their employees, containing information, electronic information in particular, so that there's not a breach of data or some horrible situation in which your company's data is taken away and publicized in some way that might get you in trouble, which I think is beginning to address a lot of the issues you mentioned, Paul, with people using cell phones and other types of devices for electronic communication that may not be as secure as a company might want, and in particular in compliance with data privacy laws. But in terms of email audits, I think that...
Could a company say all company business has to be done on the company phone and the company email system, and therefore, I mean, we can't guarantee that's going to happen, but we have a useful way of then auditing at least what we've told people should be the means of doing official company business.
I mean, I think it's a fairly common sort of policy at many companies. I think the difficulty is on the back end what to do with that information, how to centralize that in a way to protect it really on the data privacy side. But in terms of like an email audit or monitoring of some sort, I think in many other contexts, and particularly in securities trading, phone calls are monitored. Email of traders is looked at. And we're seeing that now in industries or companies and where there is a great deal of antitrust risk, having a sort of IT system in the background with some form of computer intelligence, artificial intelligence, somehow looking at or sifting through email that may contain evidence of communications with competitors or something like that, or at least monitoring for it in a way to give a company some sense of whether it needs to deploy resources for more training or maybe even talk to people about certain communications. I think we're seeing that more and more, certainly over the past 5 years as technology has developed a lot, and as companies have actually been forced to contain the information for purposes of data privacy compliance.
I want to make sure our friends in New York get their code. We are just past the 50-minute mark. The code is BLUE3, B-L-U-E 3. So that is for your CLE credit, but stick around for another 4 or 5 minutes because we still have more to go. Mary, email audits, how, you come in, you have a problem with the government, but you've had a vibrant, vigorous email audit. Does that help?
Well, I've got to believe that it should, and it does, but it may not be on an official basis. The issue is, of course, that if an employee is found to have engaged in any kind of price fixing, bid rigging, etc., there's no way around that they were doing it on behalf of the company and for the benefit of the company, because there's no other reason to do it. So, if the company had whatever process it had, somehow it got defeated by someone who was trying to increase company sales, then it's going to be an issue. That said, I think the most important issue is, can it stop the issue, the problem from arising in the first place? And I think it shows tremendous promise. If it can be done consistent with privacy, data privacy, and other employee protection laws, it shows an ability to really, for high-risk industries, without human invasion of privacy, frankly, because you'd have to use AI to do it, then you could really hone in on the matters of concern.
Yeah, if I can just add on to Mary's point here, I mean, I think in situations where you find yourself under investigation by the government and you're going into the government and saying this will never happen again, you really do have to think about special compliance measures. And at least in my experience, a presentation of an email monitoring to the government is very well received. They are, at least at the United States, they're pretty sophisticated on this, and we'll have some tough questions. They don't, as Mary said earlier, no paper programs on this. So if you can demonstrate that a serious commitment, the government will be happy with that, and the government may, may result in a reduction in a fine and a negotiated plea settlement, and it may be necessary or important to have the government not insist upon, for example, a monitor after resolving an issue with you. So these things can have big benefits for companies.
Just a few minutes left. If anyone has any additional questions, please send them in. There are a few that are in the queue. And this goes back to an issue that we had previously, talking about documenting bad conduct. And Mary, you mentioned, potentially there are times when you may want to email the competitor, say, I unequivocally reject that. When do you want to do that? And when do you want the GC to send a letter, perhaps to the GC of the other company, and say, this happened on this day, we unequivocally reject it, you may want to look into this issue? Or when's it right to do that? And then related to that, how does that play in litigation or in a DOJ investigation?
I think if there's any overhang on the first email, then I'm going to want to see the second. Practically speaking, any exhibit in any hearing or setting is always going to have the emails together, and there's just a benefit to having, if the outreach is, hey, want to get a drink, I hear we've got some market issues to discuss, then you're going to want to have it right back in the same thread where it says, no, that's not consistent with my company policy, all the best, or not even all the best. So that would be one situation. If it was an approach that was in person and an email would only seem like you're trying to foment more communication, but it's likely to be repeated, then possibly a letter from counsel would make more sense. I think if it's a one-off that's truly not expected to happen again, then maybe nothing is the best approach.
I agree with what Mary said there. I think that the circumstances are important, but action needs to happen or considered very, very quickly in time. Another thing to keep in mind is, as we mentioned earlier, the event itself is not privileged, and a written response, is also going to be potentially seen. So I think it's very important to involve lawyers on this.
One more question. You mentioned, is it AI?
Yes.
Okay. Yeah. Can you talk about that in the context of pricing and algorithms, AI algorithms?
Yeah. In my experience, I mean, it's like any other. I realize this is. We've been dealing with algorithms and how to train computers to sift through big volumes of electronic data in order to say, collect information that might be more relevant than information that is not, separating the wheat from the chaff. And artificial intelligence systems, they're very specific. The way they work the best is if you can train the system with respect to the particular email or electronic data set that's present. It involves some effort up front on the part and consistent retraining of the artificial intelligence system. But it is, again, some sort of overlay, usually with respect to email, with documents that are moving back and forth in an exchange server to sort of trap or pull away into a bucket what the computer, I like to call it the robot, what the robot actually thinks is important for humans to actually take a look at.
I think there may be another question lurking in there, which is, what happens if you have two algorithms who are doing pricing on the internet? Because that does relate to an interesting DOJ case from probably a year and a half ago now, where there were, I believe the goal was to win the box, and this was poster art that was being sold, and the allegation had something to do with tweaking the algorithm so that it would alternate who won the box instead of having pure competition. And I think it's an interesting question about how can automated systems fix a price? People can't resist taking the next step. And if you, instead of having two individuals who program something to do that, what if you had individuals who programmed algorithms but didn't talk about the goal, but the algorithms were just smart enough to accomplish the goal on their own? And it's really some pretty deep thinking about what that all means. I did go ahead and look up whether whether for sales purposes under the UCC, can you actually engage in a sale if you're not a real person? And it turns out there were some years when you could, and it got repealed because the business community didn't like that.
So we went from two guys sitting in a bar fixing prices to two robots fixing prices. Who said antitrust law isn't exciting? I think our time is up. So thank you very much. If there are any additional questions, and feel free to pass them along or call any of us, and we are happy to talk further about these issues. So thank you for participating. We appreciate it.